many questions that have come up recently regarding the citizens' rights laws that were sort of became on display in Georgia. And so, from a North Carolina standpoint, and perhaps giving more context, we actually wanted to take a moment to make sure we were sharing that information with people in the public. And so, we will get started with a tribute to for the reason that we're here, and then we'll introduce our panelists.
On February 23rd, 2020, Ahmaud Marquez Arbery, an unarmed 25-year-old African-American man, was fatally shot on a street in Satilla Shores, a neighborhood near Brunswick in Glenn County, Georgia. Mr. Arbery was a former star high school linebacker who liked to stay in shape and was an avid jogger, according to his family. His mother lives a few miles away from the Satilla Shores neighborhood, which is where he was running around 1 p.m. that afternoon. He was wearing a white t-shirt, shorts, running shoes, and a bandana. Mr. Arbery was shot to death while jogging after being pursued by two white men in a truck. His pursuers, a father and son, claimed Mr. Arbery resembled a suspect who had committed burglaries in the area. There was not any evidence of wrongdoing by Mr. Arbery. The pursuers were not arrested or charged with the crime until May. At this moment, we will have a moment of silence for Mr. Arbery. Thank you.
Thank you. Okay. Okay, and so now we're going to go on with our discussion. And I believe first what we like to do is to welcome our panelists. We have with us today Judge Vince Rozier. And one quick moment here. We have Attorney Antoine Marshall and Judge-elect Tiffany Powers. And you guys on your screen, you should now see an option that will allow you, if you would like, to share your webcam. And if you don't, it's fine. So we'll start. If you'd like to introduce yourself, Judge Rozier.
Well, good afternoon to you all. I'm Judge Vince Rozier. I'm a resident Superior Court judge in Wake County. Prior to being a Superior Court judge, I was a District Court judge for a little over 10 years. And prior to that, being a prosecutor. I'm from a place called Tar Heel, North Carolina. And so North Carolina Central for law school, Carolina undergrad, but Superior Court, more serious felonies and greater monetary amounts. And District Court, where I was before, that's more lower level felony pleas, DWIs, family court, juvenile, domestic violence, a variety of things. Glad to be sharing, but not glad that this is the reason that we are sharing, or that Ahmaud's death and what's been going on is the reason for sharing. But thank you for being here and being willing and ready to learn.
Thank you. Attorney Powers.
Hi, I'm Tiffany Powers. I've been practicing for about 24 years here, mostly in Robeson County of late. I practice a lot in Superior Court, from Class I felonies to capital murder. I'm also the DSS attorney. I do a lot of practice in our district courts as well. So we do encounter a number of cases in which people are either assaulted by other people or have occasion to have their rights impeded on by others who think that they're assisting the law. So I'm interested in what we'll find out today and others take on North Carolina's stance on this.
Okay, thank you. And Attorney Marshall?
Good afternoon, everybody, and thank you again, Attorney Peterkin, for holding this panel and sharing this information. My name is Antoine Marshall. I have been a Raleigh resident for over 20 years. I'm a graduate of Claflin University, and I got my JD from Wake Forest School of Law. I have my own practice, the law office of Antoine G. Marshall, where I deal with landlord-tenant law, estate planning. I'm a former legal aid attorney, but I think that most of my experience actually comes in through public policy. I've worked in 2 congressional offices and for the North Carolina and South Carolina state legislature.
All right, thank you. The first thing we're going to do actually is put a question to our audience, and we'll get their thoughts on that, and then we'll get your thoughts as well. We'll put a poll question up here. It says, do you have the right to detain someone in North Carolina? So for our attendees who are participating in our webcast, if you could take a vote on that to say whether you actually think you have the right to do that, and that's as far as detaining someone who you think has committed a crime. So we'll take a moment for some of our attendees to respond to that, and then we'll talk with our panel. Okay. Thank you. And it looks like 75% believe the answer is yes. You actually have the right to do that. And just one more question. Under what circumstances do you think that you could detain someone, assuming that you could do so in our state? And the choices are that you believe that they committed a felony, you believe that they committed a breach of the peace, you believe that they have harmed another person, or you believe that they have damaged another's property, or all of the above. Under what circumstances do you think that you actually can detain another citizen as a private citizen yourself in our state? And it looks like most people are saying that that's all of the above. So just from that standpoint, we'll start and we'll turn it back to our panel to see what you guys think about that.
Well, of course, all of the above is the correct answer.
Yep, that is the correct answer. And I sort of want to walk through these things and see if you guys could give us some help in thinking about what these things look like, because there is a statute, and so the average person doesn't necessarily read statutes every day, but they are held to a standard if they're going to engage in something to know what it means. So who would, if one of you guys would perhaps give us some thoughts about maybe what is a felony in our state?
I'll start off with that. Generally, a felony is an offense that carries a potential sentence of, I guess you would say, a year or more. For instance, 150 days is what you're going to get on the highest level of a misdemeanor. So that could even be domestic violence, that could be assault on a female, that could be assault inflicting serious injury. The misdemeanor version of that type of assault, it still doesn't rise to the level of a felony. Whenever you start talking about thefts and things of that sort, then you are getting to the level of over $1,000 or so. And then, of course, you could rise to the higher level of what may be a felony: murders, robberies, common law robbery, which may not involve a weapon. One thing that's come to mind with me just concerning all of this is just even the sale of drugs, because essentially possession of marijuana at a certain amount is going to be a felony, or possession of cocaine in and of itself is a felony. Does that then, I mean, essentially the laws, basically, if you go with this, says that if you notice somebody has some cocaine on them, then, or a crack rock, then you can detain them. And so it seems as though we don't really deal with this a whole lot. At least I haven't in my prosecution career, nor my time as a Superior Court judge. But on the felony level, this whole subject seems to be somewhat interesting. But I'll throw in that for breaking and entering, there is a misdemeanor version of breaking and entering. And there's a felony version of breaking and entering. Breaking and entering for North Carolina requires that there be some sort of intent to commit some sort of theft or some sort of damage within. There is a misdemeanor version where you may actually break or break the plane, so to speak. You walk past the invisible barrier of open door, but you walk to that, you break that plane. But if you don't do anything inside, or you just walk through, for example, a house under construction, and you don't do anything in North Carolina, that is still a misdemeanor. If you witness it, then that's still a misdemeanor. But if there is some sort of larceny or damage to take place within, then that may be something different. I'll even use as an example, and then I'll pass along to the other panelists, but John Wall, the basketball player for the Washington Wizards, was an outstanding basketball player in high school, just hanging out after school whenever he was in high school before going to Kentucky and into the pros. And just like a lot of other people, went into a house that was under construction but abandoned and was charged with trespass. I think it was under construction because it was a misdemeanor and not a felony. And so that's, if there are other questions or the other panelists want to chime in regards to what a felony may be, then feel free to do so.
I wanted to add, thank you for that. And I wanted to ask the next question as far as Attorney Marshall, you could share with us what exactly is a breach of the peace?
Well, if you don't mind, first, I guess a little bit of a background as far as why we have some of these laws. I know this is supposed to be focusing on North Carolina in particular, but these laws exist in different forms across the country. I mean, we've noticed what's happened in Georgia based off of their citizens arrest law. We know that we have the North Carolina, even though we don't call it citizens arrest, we call it a citizens detainer, which I have, and maybe someone more esteemed like Judge Rozier or Judge Powers can explain to me the difference between an arrest and a detention. But a lot of these laws were based off of common law, and they were passed because back before the turn of the 20th century, there were a lot of law enforcement agencies that didn't have enough law enforcement officers to actually keep the peace. So it allowed individuals to, I guess, kind of be deputized to help police officers keep the peace. And on top of that, a lot of these laws help protect individuals who do get involved from any kind of civil liability. So if you could imagine a scenario where I'm walking down the street and I see somebody steal a woman's purse, you know, without these laws in place, if I were to jump in and try to apprehend this person, and let's just say I accidentally break their arm and try to apprehend them, they would not have a civil suit against me. These laws kind of serve as protection against some of that. But generally, when you're talking about a general breach of the peace, you're generally talking about any kind of disturbance that has the chance to elevate itself. And I guess I want to say a breach of a peace is kind of a catch-all in this situation, away from some of the felony situations where you would have some misdemeanors that would constitute a breach of the peace. I think Judge Rozier kind of cited some of those where you have a domestic violence situation or an assault on a female situation where they would technically be classified as a misdemeanor under North Carolina law, but they would be constituted as a breach of the peace if the person has the ability to observe those at the time that they're happening.
Okay, thank you for that. Attorney Powers, you want to add anything to that?
Well, as far as the statute itself and the detainer versus arrest, and my belief is that with the detainer, you're holding them for the police. With the arrest, and I think you just turn them into the law enforcement center to have them processed. That really is the only difference that I've been able to determine in the research that I've done. But as far as the breach of the peace versus the felony, a lot of people don't know the difference in North Carolina between a felony and just a regular breach of the peace, or even what warrants them having the ability to detain someone. But I live in Robeson County. So we have people that will follow armed persons from an armed robbery at a bank, call the police and follow them down the road to give them the name, the make, description of cars. So when I say that we have people that will do things like that, we really do here in Robeson County. We have people who will, if they say, stay right here, I'm going home to get a gun because I'm going to shoot you. You can best believe that that person is going to go get the gun, and the other person has a strong likelihood that they're going to stay there. So we have a lot of breach of the peace in Robeson County. So if it's likely to produce violence, likely to provoke anger, it's a breach of the peace.
There's also some cases that talk about is signs and languages and gestures, and so it makes it a lot broader. So, I mean, there's lots of gestures you could engage in that it says that if it's likely to provoke retaliation, that's a breach of the peace, and so that's a pretty broad way of looking at it as well.
Exactly.
And the other,
you had a case in the Supreme Court of North Carolina where someone gave a police officer the finger, and the police officer, this was as the police officer driving down the street and saw somebody, passenger, give him a finger, and actually pulled over that car to try to say that that was a gesture that was likely to provoke violence. And as it made its way up through the courts, at one point, one court said, yes, that is a breach of the peace, but the Supreme Court just came back and said that that is not sufficient. So giving someone the middle finger is not a reason to then detain them to try to go and get the police. Or if someone flips you the bird, then that's not a good reason for you to try to detain them.
well, that's good to know. Thank you for that. One of the other things that I was thinking about when looking at what this rule, and this distinguishes it from Georgia, but you have to have probable cause to believe that the person has done these things. And most of us, including myself, I certainly did not know what that was before I went to law school. And so I'm hoping that one of you would be able to, and I know it's a big topic, but just be able to give some guidance to our attendees about what exactly does it look like to have probable cause to believe something.
Attorney Powers was to take that. I know you may deal with that a little more frequently in your area than Attorney Marshall. Otherwise, I can jump in.
Well, for us with probable cause, certainly you have to have a it's more than just a good faith basis. There has to be certainly some indicia of reliability, and looking at the circumstances with regard to all of the information that you have in making a determination as to whether or not you have probable cause. It's more than just a more likely than not standard, but you have to have a good faith basis based on this totality of the circumstances that something has occurred that rises to the level of a criminal offense. If you've got probable cause to believe that an offense occurred, then that's just one of the bases. The other is that it has been committed in your presence. So if both of these things have not occurred, then you don't have the right to detain someone in North Carolina.
Now, I'll just throw in with probable cause. One of the ways that we see it in the court system very often is whether or not an officer actually has probable cause. And so, I mean, we spend countless hearings discussing whether the officer has probable cause. So then try to take it to whether a citizen has probable cause seems to get into a whole nother subset of issues or a whole nother area. But even whenever we're discussing probable cause in court, which very often may come into play, for example, with a driving while impaired offense. First, you have to get beyond what you call reasonable suspicion. I mean, there need to be articulable facts that you can actually verbalize in detail to say why you even got to the point of pulling someone over, why an officer would stop your car. And then after they are able to engage in some sort of investigation, perhaps making you watch someone's finger or walk in a straight line and turn around or lift your foot up or count a certain number of times or different ways, then they are able to determine if there is sufficient probable cause to then arrest the person. And so we make officers go through all these different levels and tests and standards based on now very, very much centuries and decades of law to turn around and say that, well, those of us who've been in law school and gone through 15 weeks and getting to that 16th week of a semester and still trying to figure out what probable cause is, it's still somewhat of, I mean, you really need to know if you're going to exercise this type of power, citizen granted or authorized power, which I believe is why it's something that needs to happen in your presence, because an officer is going to have to do some investigation. And if they see it in their presence, that's one thing. I mean, we get into like hot pursuit and all of that, but it's not just like somebody told me, she said, he said. I mean, you can have some hearsay that you take into consideration, but it's something you really need to know.
So, Attorney Marshall, what's the downside if someone thinks that they have probable cause and they're wrong?
So the downside is they open themselves up to criminal and civil liability. If they end up being wrong, they could be charged with unlawful detainer or wrongful imprisonment. They could face some civil charges as well regarding, depending on these circumstances and the use of force in trying to detain somebody. If force is applied, then they could end up, facing assault charges. Not both criminal and civilly. Like I said, you're talking about wrongful imprisonment and or kidnapping, depending on the severity of it. So people really do need to understand, as most attorneys, most cops, most law enforcement officers would probably recommend that you do not get involved in these situations. And try to perform any kind of citizen's arrest because of the downside and liability that you attach, like I said, criminal liability from, like I said, wrongful arrest or wrongful detainment to kidnapping. You could be facing assault charges. You could be facing wrongful imprisonment charges there. And so it would be highly recommended, if I had to give any advice, and obviously it's difficult to do on a case-by-case basis. I mean, obviously, if I see a domestic violence incident happening directly in front of me, it's kind of hard to say, don't intervene, step back, call the police and try not to get involved. Especially when you get down to that third part where you talk about a crime involving physical injury to another person, to witness that, not to step in and do anything. But I would recommend anybody not to actually get involved in these situations. And one of the caveats to that, and I'll point out, thankfully, the North Carolina statute doesn't do this, but I believe it's Kentucky. They actually mandate that citizens who witness crimes actually have an authority. They have to make a citizen's arrest by law. Now, obviously, I haven't seen anybody who actually been prosecuted for failure to do so. But if you read the Kentucky law clearly, it specifies that if you witness a crime, you have a lawful duty then imposed upon you to make a citizen's arrest. Thank goodness North Carolina doesn't do that, because of, like I said, the downside to this is if you are wrong, you end up committing a crime yourself, and worst case scenario, you end up with a situation like Ahmaud Arbery.
Or am I the only person who remembers the season finale to Seinfeld, in which this was actually addressed? I mean, it was we thought it was I didn't know. I mean, this is many years ago, and I didn't know it was real. But that's the scenario Attorney Marshall was describing, which is someone they watched this guy get his car stolen, and they just stood there and watched, and they ended up being prosecuted. So I think a few people probably thought that was real because it was Seinfeld. Yeah, really.
I'm not
for years.
sure about the New York.
Gabriel, could you put up that next full question? I'll have a question that we're going to engage our audience with in 1 second here. All right, the question that I'm asking our attendees now is, it basically asks, who can change the law? Sometimes we hear things like this and we don't necessarily like them. And so we'd like to see if our attendees have a sense of actually who actually makes these decisions, so they can. So let's see what we have. Let us know the results for that, Gabrielle, when you're finished. The question, and for those of you on our other cast that can't do the the choices are the sheriff, the judges, the district attorney, or the state legislators. The question is, who can change the law?
Okay, we have 89% who are saying state legislators and 11% who are saying judges.
Well, that's very encouraging. Thank you. You can take that down, and we'll go back to our panel to get any thoughts about that, and I guess to answer the question specifically.
I can't change it. That would be my answer. Our role is to, I can't even say enforce, but to make decisions based on what the law actually is. Before we were getting started, I was looking at what we have as far as jury instructions, and even if there's a scenario like this that might play itself out, there are different ways and motions that somebody could ask that for instance, in the case we're discussing, the defendants, the men who have been charged, could perhaps ask that there be some sort of dismissal of the case beforehand, and if a judge doesn't find that there's a reason to dismiss it, then the jury gets to decide whether or not there was a reasonable attempt at detaining someone. And so while for a lot of people, well, it's a legislature, they make laws, we have to follow it, but for a lot of people, the evidence is what it is because we see it on video. But whenever you get to a jury made up of citizens from that county, who will then be asked to question whether or not they thought that these defendants, these charged, these people who committed, who killed this young man, whether or not they were rightfully in their place to try to enforce a citizen's arrest or citizen's detainment. If the jury says that yes, they were rightfully in the place, then you might end up with a horrible situation taking place, but also a possible situation.
And the follow-up to that, Attorney Powers, would be who actually makes the decision about whether someone is charged?
Now, as far as someone being charged, initially it would be those on the scene. So when you're looking at a felony and it's, in the city limits, it's the police department, outside it's the sheriff's department, but a detective would take out the charges. In this situation, it's my understanding that the DA's office sent a directive down because the DA's office, ultimately, that's the person who makes the decision as to what is being prosecuted in that district. And the DA's office allegedly advised the sheriff's office not to take out charges against these individuals. But, here in North Carolina, the district attorney's office is the one who is the ultimate decider in what is prosecuted. So regardless as to who takes out a warrant, whether it be a citizen or an individual law enforcement organization, the district attorney's office can either dismiss that or can file other charges, which would be either through warrants or through the process in which they're indicted, and it goes up to Superior Court. So that would be, who makes the decision as to who's charged and how they're prosecuted, because there are a lot of cases where other people could be charged in a scenario of some type of criminal offense, and they only prosecute persons A and B when there could be easily C, D, E, and F.
Let me chime in because I was not aware of that directive from the district attorney. I'll chime in just to express dismay, frustration, and anger because typically a district attorney actually has cover because of just what Attorney Powers pointed out. The police agency or that law enforcement agency can take out the charges. And then once the charges are commenced, then there's a whole nother step, like she said, the indictment process where a grand jury can review it and decide. And then if the police officer decided that there was sufficient evidence for a charge and the grand jury thought that there was enough evidence for an indictment, then the DA can still say, I can't take care of this case, somebody else has to have it. There are multiple ways that a DA can decide that they don't want to be involved in something that's already been charged. But for them to take the initiative to say don't charge at all is complicit to me. And so that I wasn't aware of that. That's upsetting.
Well, this is actually the third DA who's touched the case, because the first one was, as Judge Powers said, the first one sent the directive to the police officer not to arrest the McMichaels. The second DA who got the case, the mom actually, Mr. Arbery's mom actually filed a complaint against him, saying that there was a conflict of interest because the son had actually done some work with the second DA. So the father was a private investigator for the first DA. The son had done some contractual work with the second DA. I'm not exactly sure the nature of the relationship, but he had done some work there. And then he passed it off to the third DA. But before he did, he wrote a long, well, it wasn't long, but he wrote a letter basically spelling out why he would not recommend charges against the two individuals before he passed it off to the third DA. And that was shortly before the video was released to the public. But to my knowledge, both DAs had access to that video because the third person was charged. The third person involved, his nickname was Roddy. I can't remember his full name. William Roddy Bryant, who actually just got charged with murder yesterday for being involved in. So he got charged with under the felony murder rule and for unlawful for wrongful arrest or wrongful detainment and first degree murder. So all three of them have now been charged with the murder of Mr. Arbery.
Yeah, and it's one thing for the DAs to say, okay, well, cite all of those exceptions or to state that and try to find a way to recuse themselves from being a part of the decision making, but to give that directive outright is somewhat contemptible to me. I mean, for instance, there are cases where I, as a judge, can say, well, it's too close to home. I don't need to be the person to do that. But if I've already given some orders and some rulings in the case beforehand, like Attorney Marshall's pointing out, then that's I just call it complicit. I mean, it's a part of the conspiracy. I mean, because whenever one person in a murder commits an offense, and if you are aware of it, you're part of it that's going on, then under conspiracy theory, two or more people making an agreement, and whether it's before or after, there are different ways you can be brought in. And so, I mean, I don't want anybody going and saying Judge Roger said that these people should be charged also, but based on that evidence, it's neglectful. I don't think a lot of people pay attention to the oath that they actually take. I mean, people will cite the higher being, their God, whoever it is that they swore to or just affirmed because they are so diligent to the United States that they take that oath. But whenever it comes down to it, I think some people are blasphemous in regards to the oath. And that just sounds like that's what happened here. You can quote me on the blasphemy part. Don't quote me on they need to be charged.
Well, part of the point that I wanted to make sure that we made clear to our attendees was that there are aspects of all kinds of cases that people find upsetting. They don't like the investigation. They don't like who was charged. They don't like rulings. They don't like the law. But the truth is, there's a theme here. The sheriff got into position in North Carolina through voters. So did the DA, so did the judge, and so did the state legislators. So whatever aspect that a person is looking at that they don't think is right, they actually have some authority inside of that, because the person who made the decision not to charge an individual was empowered by your vote or lack thereof. The person who wrote the law that you think is not right also was elected by you. And so I don't know if everyone understands how much that relates to these issues. And so I just want to make sure that our attendees could appreciate that as well.
As far as the state legislator?
Well, it's every part of the process are in the individuals who are in charge and in control of those decisions are put there by voters. So, and I mean, I think you make a great point in that. And even when I do my political advocacy here, my thing is trying to remind people, about these local elections. Yes, we have a presidential election coming up in 2020, and it's getting a lot of oxygen when it comes to the media and news cycle. But when you look at all those down ballot races, if you're upset with your police force, well, in North Carolina, they're appointed by your city council. And here in Raleigh, as in most of the country, you get about 15% voter turnout in those areas. People who are upset about laws passed by the state legislature, people who are upset about, the judges who rule in these decisions, or as you said, the DAs who, make these decisions. Again, they're all put there by you. You have a right to replace them, or, if you disagree with the decisions that they make. But I would say even beyond replacing them, if you disagree with the decisions they make sure you get invested in and learn who's on that ballot. Not just people at the top of the ticket, but people who are further down. Make sure you know who's on that ballot. And because when these situations come up, it's one thing to say, I want to replace you because you made a bad decision, but it's something more impactful to say, I'm going to put the person I believe is going to make the best decision in office in the first place, so that we don't have to replace somebody who makes a bad decision.
And also to have relationships with the people who are in office. Because if you know who represents you, then you can call that person, you can write that person, you can meet that person and say, this is what is important to me. This is why I'd like you to vote in this manner. Those things are also important, because a lot of times when you ask someone, well, who's your state senator? Who's your state representative? They don't know what district they're in to even answer that question. So people really have to know who represents them and how they can contact these people, and then to use that power. So your voice is your power, your vote is your power. So when you know these things, you act on those things, and it's harder for people to act against you if they know what your position is, and that you're going to be at their door saying, okay, we had this discussion and you knew I was coming to say I didn't like that. If you've already had the discussion, if you're there, if you're vocal, if you have a relationship. So that's what people really need to do, is to, vote their power. They need to voice their opinions and to develop these relationships, so people at the table, or be at the table, but the people at the table know what your position is and respect that position.
I would just add on to that by encouraging that in order to do exactly what has just been pointed out, go ahead and establish those relationships in advance, so that even whenever they have to make a decision, so that if they are familiar with you and you've given them so much insight in regards to who you are and the things that you represent, even before there's a bad decision that's made, then they may think about the conversations that they've had with you beforehand. You may actually be able to feed into that process as they're making those decisions. So I love the thoughts that have been shared in regards to having those relationships. There have been times where I've been able to make a decision in court, and because of relationships that I've had outside, I have an understanding of the impact that that decision is going to make. Maybe not specifically all the details for this individual person, but just by being familiar with different programs or different opportunities. I mean, there have even been times whenever I've been able to suggest things that attorneys weren't aware of, just because of relationships that I've had. And so if you're engaged, you're listening to this, and you're the type of person who's going to be able to have that knowledge and take that information and utilize it in some sort of way. So yeah, kudos to what the other panelists pointed out.
Thank you for that, you guys. Gabriel, could you go to that next question, please, and read it out loud if you don't mind?
If you and a friend are accused of stealing from a store, can the store owner force you to stay until the police arrive?
Yep.
Okay, and the choices are yes or no. All right, and it looks like 100% of our participants are saying yes. So I'd like to get some feedback from the panel on that, please, that thought.
Oh, well, that
Yeah,
happened to me. That was one of the most terrifying things that ever happened as a child. I went to a neighborhood store, and there was a young man that was there that was stealing. And I had never heard of it. Well, first of all, I'd never been around somebody who was stealing from a store. And they locked that door, and everybody had to stay in the store until the police came. And it was terrifying. I understand the premise, but it is scary. As a child, being at a store and waiting for the police. They're not coming for me, but they're coming for this person, and he's having a fit trying to get out the door, which that was not happening. And then there are these adults who are like, I got to go to work. And, you know, so everybody in the store is on lockdown until the police get here. So no one really thinks about that aspect of the ability to, you know, hold a person, but that actually happens. So, yeah.
So I would say, I mean, yeah, I mean, the answer would be yes. I mean, obviously, you read the statute and number 4, which would be a crime involving theft of property. It clearly falls under that situation. I believe the store owner would have probable cause if he witnesses somebody trying to steal from the store. I will say, in practicality terms, that would generally happen at a mom and pop store. A lot of the larger chains, you know, the Walmarts, Targets, they have people on staff where they actually instruct people not to, they instruct their employees not to follow anybody, but to call the police. They've got cameras everywhere. They generally catch people that way. But yeah, I mean, obviously from that example, yes, detention is permitted when there's crime involving theft. This is a crime involving theft, and yes, you'd have the right to detain anybody until the police arrived.
For me, I would say it depends. I think that the citizen does have the right to detain whenever they witness that probable cause exists and it's in their presence. Just like Attorney Marshall just pointed out, I think it probably falls under more of the mom and pop scenario. I remember having cases where you have security officers at a store like Sam's Club, and if they believe that they've witnessed something, then yes, I think they have the right to detain you. I think the question more so was not on their right, but on your obligation. And I just think of the mom and pop store, or even Attorney Powers scenario, where, or just putting myself in that someone's shoes, and I'm walking out of a mom and pop store and somebody just accuses me of stealing a popsicle. Do I personally have the obligation, just going with the wording of the question, do I personally have an obligation to heed to their requests? Should I? Perhaps so. Do I have to? I don't. I mean, I'm saying I don't know. That's just who the burden is on. I mean, it's kind of a burden shifting type of question. And so it's better to do so. I mean, Judge Craig Kroom always talks about comply and then complain. That's whenever it's law enforcement. You comply with what's going on, and then you have the opportunity to complain later on. So whether it's best to wait, probably so, especially if you didn't do it. Do you have to? It probably depends on the scenario.
And I would want, thank you all for that, but I would want to add there are limitations. Earlier today, we did an attorney training, and one of our cases had someone who stole some beer from the store, which she did. And as she was leaving the store, the owner was telling her to come back, and she didn't. She gets in her car and she drives off, and the owner of the store actually comes out and shoots at her. Because in his theory was that he was doing a quote unquote detention because he didn't want her to evade arrest. And the court said that was not reasonable under the circumstances. And so even though there is a rule that talks about how you can be detained, the method and the process still has to be reasonable. Our example that we had was reasonable, but I don't want our attendees to think that, as Judge Roger said, there is a maybe attached to it because there is a limitation when it's unreasonable. And so the court did find that shooting at someone who had left the store, who was stealing beer, was actually unreasonable. And that person did not have protection, and they were actually, and that store owner was actually charged.
I would say, I mean, with that example, I would definitely say that would be unreasonable because there are some limits as far as use of force and whether or not you use a reasonable amount of force in detaining somebody. I would think that, you know, the example, you know, somebody locking the door, the example that Judge Powers gave of the store owner locking the doors and saying, you've got to stay in here until the cops come, you know, obviously is they're not using force in that example. Obviously, if you're shooting at somebody who is driving away, then yes, you are using excessive force in trying to enforce this detention. And I will say, I mean, this is my personal opinion, but that's kind of where some of the flaws of the citizen's arrest or citizen detainer law kind of fall apart is that burden shifting that Judge Rozier talked about. Yes, somebody may have a right to believe that they have probable cause to stop me for a felony, but what are my rights to say you don't have probable cause, and if I am to leave the scene, or what rights do I have to make sure that at what point does it kick in that it's self-defense? And I mean, we look at it with the Ahmaud Arbery scenario, where these two gentlemen felt like they had the probable cause to stop him. They did not, and we can argue about whether or not their probable cause, whether or not it was reasonable for them to think that they had probable cause. But at what point does Mr. Arbery have the right to defend himself from what would be a wrongful, detention, or kidnapping attempt? What right does he have to defend himself from that? I mean, let's just say he had a weapon on him and he used that weapon in defense of these two armed or three armed gentlemen trying to block his path. And then it really becomes a burden shifting, and it really becomes a very, very specific, factual case based on the facts that happen on the ground. It's very hard to determine at what point his rights to self-defense supersede their right to try to do the citizen's arrest.
Right. Let me throw in just a couple other things, or to go along with that. Whenever a judge is instructing a jury about whether or not how long someone can be detained, the instruction that we would give is that the detention may not last longer than the time required to determine that no offense is being committed. So there is some, it's not an indefinite period. It is a short period. And then just to go back and touch on what Attorney Marshall just pointed out, I'm concerned about how this case is going to play out, just because of exactly what he mentioned. Whenever we talk about burden shifting for the non-lawyers out there, it means that at each different stage of an occurrence, the police may have the burden to prove that there's probable cause, and really the burden doesn't shift to the defendant. But whenever there's a self-defense scenario, then you may start off with somebody saying, okay, the prosecution has the burden to prove that this person is guilty beyond a reasonable doubt, but then it may shift and the defendant may turn around and then they have put on the state the burden of also defending about whether or not the shooting self-defense was reasonable. I may have just explained that poorly, but let me get specifically to this case. We mentioned before, we're here discussing whether or not those men had a right to be there. If the jury determines that they had the right to be there, that ends that discussion. The way that it goes through a jury is there's just one question on that one issue. And then once you make that decision on that one issue, if he had the right to be there, yes, he had the right to be there and to enforce a citizen's arrest. Then you just move on. You forget about all of that. You move on to the next thing, which Attorney Marshall was just describing. Where we know that in certain states, there are laws that allow you to have your weapon and point it at somebody. And if you then feel threatened by the person who is on the other end of that barrel, then there are certain exceptions under these laws. I mean, for instance, look at Trayvon Martin in that scenario. If this person that is now charged with committing the killing can, through presentation and arguments to the jury, point out the fact that, okay, well, Ahmaud grabbed the gun. Yeah, it was reasonable that he would grab the gun, but now they're going to try to shift it to a whole nother scenario and say, well, he grabbed the gun, so I was in fear of my life because you've already decided that I had the right to be there. And so now there's this whole discussion about whether or not it was reasonable to pull a trigger when you have somebody on the other end of your gun. I'm just concerned because I don't know this county in Georgia, but going off of the district attorney and how long it took for us just to get to this point, I just have my concerns.
Oh, this county has a really bad history with regard to cases of this nature. There was a case of a young lady that was in a car that was fleeing and was, I think she was shot several times. And of course, that was found not to be excessive force. And it was a justifiable shooting. There are several other cases similar to that that were questionable. And that just has been a pattern in this particular county. So it gives you cause for concern.
Well, thank you guys for that. If you all have any other thoughts as we're wrapping up our panel discussion, we now would yield to you to share that.
I guess my final thoughts with this, I mean, we talk about the theories and what the statute says, and we put out fact patterns. The one thing that I would just like, unfortunately, the evidence is never quite perfect as far as the fact patterns that we can put out there. We can talk about the statute, we can talk about hypothetical situations, but when it comes to everyday practice, it is very, very rare that you have all of these facts just sitting there and plop down in front of you on your lap. With the Ahmaud Arbery situation, it's pretty clear that these gentlemen wouldn't have gotten off with this if it were not for that video. It was once that video became public that you started seeing, presidential candidates. You started seeing, well, the president said it himself. President Biden said it. You started seeing athletes. You started seeing celebrities also jump in, and the public at large kind of came in and said, "What's going on here?" And I think that, to me, that's probably the most concerning part of this case is the idea of not knowing how many of these cases are out there that just don't have this perfect evidence. We don't have a video sitting there. And it kind of reminds me of the Walter Scott shooting down in Charleston, where we saw Walter Scott running away and the police shot him in the back and then tried to plant evidence. And for a long time, nothing would have happened in that case if not for that video. And so kind of, the concerning part to me is how many of these cases have slipped through unnoticed, where the only witnesses to the who can attest to what happened are the ones who survived. And they paint a picture that, I mean, even with this case, when the police contacted Ahmaud Arbery's mom, they told her that he was involved in a burglary. The police told her that he was shot and killed in trying to commit a burglary. And I can only imagine what the grief that his mother faced from getting that information, not only that her son was dead, but was supposedly involved in a crime. And then we see from the video that something else happens. So I think that that's one of the things. I mean, we can talk about fact patterns, we can talk about the statute and things like that, but how it plays in everyday life is something that we're still trying to come to grips with. And in many of these situations, without that smoking gun evidence of a video showing, generally what happened, many of these cases get swept under the rug.
Well, the other takeaway from me is let the police. If you see a crime, then report the crime. But I don't suggest anyone to just run out and try to detain people. I know of cases where people have blocked people in with their cars and things like that. That kind of thing that happened in the Wild West, or happened back in the old English days when we did not have enough of a police force. That's not necessary today. You can tweet, you can take pictures, you can send out whatever it is you need to send out to get the law enforcement there. They will be there in a matter of minutes. So don't put yourself in danger of being either the Ahmaud or being the McMichaels or whomever else. Just call the police, because they have a job to do and they will do their job gladly. So call them. But the other thing is, if you don't like the way things are going as far as when these things happen and how it ends up, then you need to be active in your community. You need to have a presence at the tables that are making the decisions. You need to vote, and you need to make sure that you fill out your census.
I guess 3 thoughts. I wish it was something profound, but 3 thoughts. The first one being, since I'm from right next door to Robeson County and used to go shopping there, that I need to get a concealed carry permit before I go in case something happens. I'm just joking. But one other thing is, we talk about in legislation that is an ugly process. You don't like to see the sausage being made. I would like to believe that what we are experiencing now, just like Antoine pointed out, is just the unveiling of what's been happening for years and years and still happening now, but it's unveiled just because of the ease of technology and putting it on camera. What I have to remind myself of is that if it wasn't for that camera that is causing us so much angst, it would have just been somebody else who got away. And perhaps the next person's a little deterred, even with police video and police cameras and body cameras, that there is likely to be less happening now, even though we see it more. And so I try to remain encouraged somewhat, even though this one, for me personally, this one just hurt because I run, and I mean, it actually changed my, not only did it affect me emotionally, but I mean, it's like affected what I do in my own daily life. But then also just last thing is just be aware of, I saw an article about unreasonable fear. If people didn't unreasonably fear us as Black men, very often we wouldn't have these situations. I mean, this is a situation, I mean, the unreasonable fear that goes back to abolition. I mean, you can look at Birth of a Nation. I mean, there's just the movie or the book. There's just this unreasonable fear. And the more that we do to get into the psychology, the people so that they are not unreasonably afraid of Black men or just unreasonably afraid of different people, then some of these challenges are enhanced, or they're not as severe. But that, on the flip side, if we don't do more to try to alleviate some of the problems that we have to be honest do exist, then people are just going to see the media put out the Black men on TV that did commit an offense, and go with that, and that's just going to cause more people to be unreasonably afraid. And so we need to do whatever we can do on that front, on the social and psychological side.
Well, thank you guys for taking the time to share this with us. I think one of the biggest parts that we get to play as lawyers is education. And so that's something that I felt like was lacking. And I appreciate you helping us participate in a process that gave people that opportunity to have real and accurate information. We're going to take a slight transition. If you would hang on with us, Gabrielle, could you pull up your PowerPoint to announce our scholarship winners? And also, just to make sure we don't have any questions from our attendees before we do that.
Hey, I don't think we have any questions online.
Okay. So can you make yourself the presenter so that you can show the PowerPoint?
Yes, sir, I'm doing that now.
Right. And while she's doing that, again, thank you to our panelists. And now it might sound like an odd transition, but at least it leaves us with something hopeful and positive. This will be our 6th year giving out a scholarship to students in Robeson County. And we ordinarily would come to their awards day on campus and do that, but we thought we would announce it today anyway. At each high school in the county, there will be a student who gets $1,000 that they will be able to use for expenses directly related to basically getting to college. Most scholarship programs send the money to the school, but our scholarship program is a direct assistance program, meaning that the check goes to the students. The students may need money for clothes and transportation and just whatever they need that's going on. They can use the funds for that. And so we've done that now. This will be, again, our 6th year, and we're excited about it. And we're now ready, if you're ready, Gabrielle, to announce our 2020 winners.
And I also did include our honorable mentions if you wanted to mention those.
Certainly.
Okay. Our first school is St. Paul's High School. Our honorable mentions are Erica Gastro, Ashanti Gillis, Brianna Tolson Tucker, and our winner is Marquise Coleman.
Congratulations to those students at St. Paul's High School.
Yes.
Right. Next, we have Purnell Sweat High School. Our honorable mentions are Aston Barch, Haley Clark, Michaela McDaniel, and our winner is Zachary Scott.
Congratulations to those students at Purnell Sweat. People are
Okay.
applauding you, I just can't hear it.
Okay, our early college high school winner is Zakia Blackburn.
Congratulations, Zakia.
Awesome.
Okay, Lumberton Senior High School, our honorable mentions are Zakira Williams, Kayla Shotwell, Tyler Maydean, and our winner, Kaylee Fields.
Yay. Go Pirates.
Somebody's an alum of Lumberton High.
Okay. Fairmont High School, our honorable mentions are Jamina Pegues, Jayla Gaddy, and Shaasia Chavis. Our winner, Tristan Collins.
All right. Tornadoes.
And last but certainly not least is Red Springs High School. Our honorable mentions are Benice Zangaga, Trinity Murray, Michaela Hammonds, Tasha Campbell, and Quentin Galbraith. Our winner, Danielle McAllister.
Very good.
So special shout out to all of our scholarship winners and honorable mentions. Thank you for all your hard work and dedication.
Thank you for that. And again, thank you guys for participating with us today. And a special thanks to our panel for taking the time to share this information. And we hope you guys have a safe and socially distant Memorial Day weekend.
Absolutely. We'll be socially distant from the beach. We'll be just here in Robinson County, but thank you.
Absolutely. Take care.
Bye-bye.